Go ahead and call the first case, Element LLC, Appalachia versus Rodney Harris et al. If you would please state your appearances.
Kirk May, Your Honor, on behalf of the appellants, defendants below, Mr. Harris, Pirolli, Simmons, and Walz.
Okay.
Good morning, judges. May it please the court, Matt Geiger appears for plaintiff Appalachia Element LLC.
And Mr. May, do you want to reserve any time for rebuttal?
Please, Your Honor, 3 minutes, if that is appropriate.
That's fine. So
Thank you.
12 and 3, and let me get my cell phone out. I won't be texting or being on Facebook, but I will use it as a clock. So let us do that. If you want to come on forward. And you may begin whenever you're ready.
Thank you. May it please the court, Your Honor. Kansas Statute 17-7663 expressly provides that a manager of a limited liability company is to be treated as though they are bound by the operating agreement of an LLC, even if the manager doesn't sign it. The appellants in this case were managers of Element. The statute also provides that Element itself, a limited liability company, I'm quoting now, is bound by its operating agreement whether or not that limited liability company executes the operating agreement. The upshot of the statute is a manager or the limited liability company itself is treated as having actually executed the agreement. I describe it as they statutorily executed. And interestingly, the same statute also applies to a member. So a member, even if they don't execute an operating agreement, is nonetheless treated as though they have. And that's the thrust of the statute. Element, the LLC, therefore, was a party to the operating agreement, as were the managers a party to the operating agreement.
And your clients are managers, not members, correct?
Managers, correct, Your Honor.
But their duties were defined in the operating agreement.
Yes, Your Honor, and in fact, there's a specific provision in the operating agreement that defines the fiduciary duties. That very same provision is quoted in the plaintiff's below, in the petition, okay, and is one of 2 paragraphs where the plaintiffs say in their petition, the defendants, the appellants in this case, breached their fiduciary duties.
So is it your position that their claim, of course we can ask them about their own claim, but is it your position that their claim arises at least in part out of the operating agreement and the fiduciary duties owed by the managers?
Absolutely, Your Honor. And that position again is, when you look at the petition, you'll see the operating agreement referenced frequently through it.
There's some argument, though, that they're just trying to enforce a common law fiduciary duty. So help me understand what you see the distinction here is in this case, if any.
Well, this may be a case where there's no distinction between the two substantively, okay, maybe, but what they have pled, Your Honor, I believe it's in paragraphs 88 through 90 of the petition. They have specifically pled that provision, Your Honor, asked about, that defines fiduciary duties for the managers, and has said those fiduciary duties have been breached.
And the operating agreement, just to cut to the chase, I mean, there's all kinds of other agreements, but the operating agreement does require arbitration, is that it?
It does, Your Honor. There's no dispute about that, and the arbitration provision in the operating agreement uses the typical, but nonetheless, as the Kansas appellate courts have observed, broad language of any dispute, controversy, what have you, arising out of or related to the operating agreement. And the manager's authority and their requirements, things they have to do, flow directly from that operating agreement. They're only managers by virtue of the operating agreement.
So let's say we agree with that part of your position. then we get to the order, the receivership order.
Yep.
And does it not provide that even though, let's say the operating agreement controls arbitration would generally be required, but doesn't it still require leave of the district court?
I would not agree it requires leave necessarily, Your Honor. We sought leave in this particular instance to ensure that we were complying with the receivership order. But more importantly, and I should note, the district court's ruling below was premised, and at least at one point, and one of the premises, if you will, was that Element was not a party to the operating agreement. And that is legal error because of the statute. And the district court's not free to disregard the statute and under the guise of exercising discretion. For example, the receivers, I'm sorry, Your Honor.
Well, you would agree an abusive discretion standard governs our question here today?
In this sense, Your Honor, that as a matter, if in exercising one's discretion, there is a legal error in which the discretion is based, then that discretion has been abused. And I think the court's cases are clear on that. That's the situation we have here. First example, Element's not a party to the operating agreement, or the managers aren't parties to the operating agreement. It's a legal question. There's a statute. The statute makes them a party.
But you would agree, though, and certainly one way you can get abuse of discretion is a mistake of law. But so you've stated that certainly correctly, but it is a discretionary call, assuming that the facts are applied correctly, the law is applied correctly, and it's reasonable. It is a discretionary call for a district court to decide whether to grant a party leave to do so.
I can't say generally whether that would always be the case or not, Your Honor. In this particular case, I can say that there was a provision, it's section 15B of the receivership order, it's in the appendix to that, that provision does provide, begins with, without first obtaining leave of court. And that's what was done in this case. And the provisions on which the court relied principally, and on which the appellees rely on this appeal, are found at 15B, little I, Roman I, and Roman 4, okay? And then 6D. And if I might, 6D, Your Honor, again, in interpreting these and applying these, okay, you can't base your decision on a legal error, right? You cannot, well, you can, and if you do that, it's an abuse of discretion.
But we can affirm for any reason if they reach the correct result.
Well, there has to be some evidentiary basis, with all due respect, Your Honor. I don't think you can.
Sure.
Yeah,
Sure.
and there is none here.
Why doesn't 6 give us that authority?
Well,
6D.
okay, because 6D says the receiver, okay, shall not be bound by any contracts, agreements, or other commitments of Element or the receivership businesses, or any of their respective directors, equity owners, agents, employees, or other representatives. Those are managers included in that, okay? So what that says is managers, representatives, okay, who have a contract with a third party, right, are not bound to follow that contract, because they're just like the receiver in that provision. So that provision, I don't find any ambiguity in the construction of it. Otherwise, I believe would be legal error. Essentially the same rules that would apply to interpreting a contract.
So you would simply say that 6D, because it's talking about contracts with third parties, does not apply to the operating agreement or any of the other agreements that were entered into here?
Yeah, I would say by its terms, it would not apply to certainly the operating agreement and any agreement in which a director, equity owner, agent, employee, or representative of element, okay, is the party. So those people under this under this provision can't be a third party, because they're talking about the third parties are people who the managers in this instance, or element in this instance, have contracts with, that are not one of these. It doesn't apply, for example, if you had a manager versus manager, right? Because they can't be third parties under the literal language of 6D. 15B, Your Honor.
And let me make sure I understand
Okay.
what you're arguing there, that because they are managers, they are created by the operating agreement, their duties are expressed in the operating agreement. Because of that, they cannot be third parties to the agreement. They're controlled
Well,
by the agreement. Is that?
That's true also, Your Honor. They also can't be a third party by virtue of that. But
That's why I was trying to figure out why are you saying that they can't be a third party?
well, because they're a party to the operating agreement. So they've got to be outside the operating agreement to be a third party vis-a-vis the operating agreement, right? Well, just like a member who doesn't sign it but is treated as executing the agreement is not a third party. But more specifically, the literal language of 6D, okay, is a different way, I guess I would describe it, Your Honor, of getting to the same place. And it makes clear that if you're a representative or agent, like a manager would be, okay, they're talking about situations that manager has with a third party. So this provision does not apply to managers, because it's talking about element and relationships it has with third parties. Okay, and an element and the manager under 6D are essentially in the same position.
How do we then handle 15B4, I think it is?
Well,
The district court has exclusive jurisdiction over receivership property. Now, I'm not quoting, but I'm paraphrasing.
understood, Your Honor.
But how does that play into all of this?
Well, the motion to compel arbitration in the arbitration procedure, okay, does not interfere with the jurisdiction that the district court has over the property, the asset, if you will, the cause of action in this case, right? And we know this, that there,
I guess I don't understand that statement, because the concept of arbitration is to resolve the issues.
well, the
Wouldn't that be taking it away from the court and the receivership?
Well, you haven't taken away from the court the exclusive jurisdiction to manage the property of the estate. In other words, for example, there could be the receiver may have a claim against some vendor in Colorado, okay? And they can't make that Colorado come to Kansas and litigate in Sedgwick County.
But you do agree this claim would be receivership property.
Don't dispute that, Your Honor.
And when we we do it all the time, and we do it too, we throw around the term jurisdiction. What type of jurisdiction are we talking about there? I think in rem jurisdiction. Is that what we're talking?
I think in the receiver context, it's most appropriately viewed as over the property, the assets of the entity that's in the receivership.
And
which
certainly the district court could have ordered binding arbitration either under this, could order other forms of alternative dispute resolution. I guess our question boils down to, did the district court have to do that?
And on that issue, Your Honor, again, the district court, okay, given all the body of law in the Federal Arbitration Act, which all the parties agree governs this, the district court can't ignore an arbitration clause that's enforceable and enforceable under the Federal Arbitration Act. Just as a matter of, I'll say supremacy, but can't apply the Federal Arbitration Act if the denial of the motion to compel is inconsistent with that, which I think it is, that's a legal error that the district court committed. And again, it's almost an argument that the appellant makes, I think fairly viewed, is some fashion or another, the appellants waived their right to arbitrate, right, by agreeing, although I should note the appellants in this case, they're not parties to they weren't parties to the receivership, they didn't negotiate, but they are managers of Element.
And they certainly affect the property of the receivership.
That's the allegation, yes.
Yeah.
That's the allegation.
I need to tell you, you're almost to 15 minutes, so why don't you wrap this part up, see if we have any questions, and I'll give Mr. Geiger a little
Okay,
extra time if you
okay.
need to. But he's probably gonna argue twice anyway, I don't know.
Okay. Let me just address briefly, Your Honor, the other bases the court found, and it revolves around this master services agreement and the notion that somehow that was the last and best expression of the party's intent. Just to frame the time, keep in mind, at the time that master service agreement was executed, there was also an amendment to the operating agreement. Okay? The original operating agreement we talked about was executed in March of 2018. Fast forward to December of 2020. Okay? There's an amendment executed, and the amendment even refers to the master services agreement and says in section 1D, and it says there that contemporaneously with this amendment, we're also executing this master services agreement.
That's the management services agreement?
Yes, I'm sorry, management service agreement, correct. So they're contemporaneously being exercised, okay? The amendment expressly says what provisions are being amended, and it expressly provides that the members have sought and obtained the supermajority vote of the board, which under the operating agreement is required before there can be any amendments to the operating agreement. Has to be agreed to by a supermajority of the board, which wasn't the case, not indicated on the management services agreement. These documents are executed contemporaneously, and most importantly, the amendment, Your Honors, expressly provides, no implication necessary, expressly provides that all other provisions of the operating agreement remain unchanged and continue in full force and effect, which obviously would necessarily include the arbitration provision in the operating agreement. And any construction, Your Honor, that would impute an amendment to or a change to the arbitration provision would be unsupported by the evidence, frankly. Would just be erroneous. And it's also significant the management services agreement itself provides in section 10B, Roman 2, that nothing in that agreement contravenes anything in the operating agreement. That's amended at the same time, and that is made clear that all provisions in that operating agreement remain unchanged.
Do we have any questions?
I know.
Okay, we'll go ahead and give you a little rebuttal time.
Thank you, Your Honor.
Mr. Geiger will be flexible in the time, and as our former colleague, Judge Joseph Perrin used to say, if you don't want to use all the time, we're not going to penalize you, but so we will give you a little extra time in light of.
Very good, judges. Thank you for having me here today. This is one of the still joyful things that lawyers get to do, is come to court and argue, and it's more and more rare. And so I still get, after 30 years, a bit of giddy excitement. So I hope you'll bear with me. One of the great lessons that Mr. May taught me when I worked for him was attention to detail. And I'm going to honor that lesson today by starting with 17-7663, which is where he started his argument in subsection M. The entire argument of appellants is based on a faulty premise, that the managers are parties to the operating agreement. That's not what the statute says. The statute says a member or manager of a limited liability company is bound by the operating agreement, whether that member or manager signs or not. But it goes on to say an operating agreement may provide rights to any person, including a person who is not a party to the operating agreement, to the extent set forth therein. So, what rights does the operating agreement give them?
Now, who are we talking about then?
The defendants, the managers.
All right, just want to make sure I was following you.
Thank you, Your Honor. Record Volume 2, page 48, is third parties. This is what rights the operating agreement gives the managers. Nothing herein expressed or implied is intended or shall be construed to confer upon or give to any person or entity other than the parties to this agreement and their respective successors and permitted assigns any rights or remedies under or by reason of this agreement. So when you read the statute together with the third-party provision in the operating agreement, it's clear the managers are not parties. Parties is a defined term, and it doesn't include the 4 individual defendants who are appealing today. They don't have any right to compel arbitration under that operating agreement. And we'll talk about Hemp Hill in a second.
Well, you're making now, attention to detail, you've now convoluted 2 different arguments. You're saying that the managers are not members, therefore they're not parties to the agreement. That doesn't necessarily mean that they couldn't be third-party beneficiaries to the arbitration clause. But I assume you have an argument why they are not.
Record Volume 2, page 48, third parties. They're expressly excluded under the operating agreement. That third-party language doesn't give any rights or remedies, including the right to enforce an arbitration clause, to the managers.
Even if your claim, and we're going to talk about this in a second, you probably anticipate this, even if your claim, let's say your claim was solely based on the operating agreement against the managers, and certainly in part it is, and that seems to be a little convoluted because we don't have any record to review. This is early in the case, but it appears in your petition that you're arguing that you're trying to make, I think, a common law fiduciary, breach of fiduciary duty claim, but you cite as support of that back to the operating agreement and the fiduciary duties owned under that, which under, I know Hemp Hill is not binding on us, but certainly it could be persuasive to us. Professor Lieben wrote it, if I remember right. So, but he really hung his hat on the arising or related to part of it. Does this claim arise or relate to the operating agreement?
It clearly relates to the operating agreement because there are petition allegations about the operating agreement, but the cause of action stated is breach of fiduciary duty under the common law.
Is that simply to avoid arbitration, or why would you cite a specific source for a duty if that's not the claim you're making?
Because if I would have sued these defendants for breach of contract, you know what their defense would have been?
I think I do.
We're not parties to the agreement. And they would have won a motion to dismiss because they're not parties to the
At
agreement.
least you wouldn't have arbitrated.
And they would have been able to dismiss. And so that's why they...
But it does seem like, and I recognize that's a sound legal tactic, but it seems like, we can't get concerned too much with what the legal gymnastics going on. That's why we have 2 professionals here. What we have to be concerned of is what is really the basis of this claim. And certainly part of the basis of this claim arises out of the operating agreement and the fiduciary duties owed to the manager. The managers wouldn't have any fiduciary duties, would they?
They would.
Well, how would they even become managers but for the operating agreement, which allows managers? Not all LLCs have managers.
If there was no written operating agreement, and an LLC can exist without a written operating agreement in Kansas.
Thousands of them.
If there was no operating agreement and it was a handshake deal between a bunch of buddies and one of them decides to be managers and there's no rules written down anywhere about what that manager is supposed to do, that manager owes fiduciary duties to the entity and to the members. And those are a creature purely of common law.
Now, and I don't think you were trying to limit it to that, but you said if one of the members, there's a difference between a member manager, a managing member, versus a third-party manager.
But the fiduciary duty is the same. the
So
manager.
you're saying that even though you put it in the petition, you're not trying to make an allegation that the fiduciary duty that you claim was breached arises out of the operating?
I think that it arises under the operating agreement or it arises under common law. I think you can look at the Kansas case law on fiduciary duties that managers owe the LLC, and everything that's in that petition would exist independent of the operating agreement.
It could, but here, you're arguing that it does both. And you're trying to sidestep well, I don't know if you're even trying to sidestep, if you're putting it in the petition, the obligation, fiduciary duty under the operating agreement.
The operating agreement does not give these individual defendants any rights to compel arbitration. Set aside for a second, the receivership order says they're enjoined from doing this.
Well, and we do need to get to that.
They're enjoined from doing this. And the most recent expression of the party's intent, as found by the district court, was the MSA. If we even get to the operating agreement, which is third in line in our argument,
So the receivership order should control according to you.
the receivership order should control.
And and I think I started it, my questioning with Mr. May, the receivership certainly leaves it to the discretion of the district court whether to compel arbitration or not. Is that an abuse of discretion standard, as Judge Gardner asked? And if so, was discretion abused in this case?
It was not. The district court considered the briefs, conducted oral argument, and this is probably as good a time as any to talk about Judge Gardner's opinion in dueling, which comes into play here. A motion to enforce an arbitration agreement is a summary judgment type process for the party seeking arbitration. The appellants had the obligation to prove an enforceable arbitration agreement with Element. And the district court looked at all the papers, heard the argument, and reached the conclusion that there was no enforceable arbitration agreement. The Court of Appeals presumes the district court made all necessary factual findings from the evidence to support its decision. The court found defendants did not meet their burden, and this negative finding is only disturbed on appeal absent, and I'll have to read this because I don't want to get it wrong, arbitrary disregard of undisputed evidence or some extrinsic consideration such as bias, passion, or prejudice. So if there was supposed to be some findings of fact, it was the appellant's obligation to ask for it, and they didn't.
And the journal entry refers back to the bench ruling, correct?
It does.
Okay, so whatever, usually in a civil case, what's said on the bench stays on the bench, but once there's a journal entry incorporating it, that's where we look at the findings, and if we needed additional findings, you're saying there should have been a motion to supplement the findings.
That would have been up to the appellants. The Master Services Agreement, Management Services Agreement, MSA, the MSA, is the last effective dated document. So there's been a lot of argument in this case about who signed what when. All that matters is the effective date of these agreements. And the latest effective date, there's no dispute about this, is the MSA. And the court looked at the MSA, concluded it was the latest manifestation of the party's intent, and that finding cannot be overturned absent arbitrary disregard of undisputed evidence or some extrinsic consideration. And none of that's before the court. So the appellants lose on the receivership order, which enjoins them from doing what they've done. They can't show an abuse of discretion in the court following and implementing its own order, which is a matter of discretion. They lose on the MSA because it's the most recent document, and it says all disputes are in Sedgwick County, Kansas, not in arbitration. And even if you get past the two of those, this case is different from Hemphill because in Hemphill, the parties entered into a contract that specifically said third parties can compel arbitration. Our contract, the operating agreement, if you assume that is the operative contract, says third parties don't have any rights at all. It's a totally different provision, and so the whole estoppel argument falls apart on the difference in that provision. Estoppel is inducing somebody to believe something and then it being unfair when they believe it.
Now, would the district court have had the discretion to order the parties to participate in arbitration?
To get there, the court would have had to find that the MSA was not the latest expression of intent, would have had to agree with appellants that the operating agreement was the latest expression of intent, would have had to ignore the third-party beneficiary provision in the operating agreement, and would have had to stretch Hemp Hill beyond what it is now just to promote arbitration. And I understand there's a lot of favoritism.
And that's
for
also
arbitration.
because, well, certainly, we're to favor alternative dispute resolutions, including arbitration. Of course, arbitration is a little different because it's binding. Certainly, a district court could order the parties, well, the district court could appoint a special master. The district court could order mediation, probably even what we loosely called in Shawnee County conciliation for recommendations. But it seems like what you're arguing is that it's just that the district court would not even have the discretion to order binding arbitration. Is that what you're arguing?
No, Your Honor.
Okay.
What I'm arguing is to get to that conclusion, the court would have had to clear several obstacles that the court didn't make findings of fact.
And it's difficult because it's so early in this case. And I understand arbitration has to be, well, to be any effective, to be less time, less expensive. But I mean, we don't have much of a record to go on. We have the various different documents, but we have no underlying facts to speak of.
Well, here's what we know from the record, and we can find this in the transcript. What we know is the court exercised discretion under the receivership order and concluded that the MSA was the most recent statement of the party's intent, and that called for dispute resolution in the District Court of Sedgwick County, Kansas. That's what we know. And for the appellants to overcome that finding, they have to prove arbitrary disregard of undisputed evidence or some extrinsic considerations such as bias, passion, or prejudice. And they don't have the record to do that. And that's why the district court properly denied the motion to compel arbitration, and that decision should be affirmed.
Questions?
Thank you.
Thank you. And Mr. May, I'll give you a couple minutes here.
Your Honor, on the receivership order issue, again, the basis articulated by the district court, and it's in the transcript, which is part of the order, okay? Clearly, the court's basis are stated. There were no findings of fact to be supplemented. Those were legal conclusions that the district court drew from two documents, okay? The management services agreement, the amendment to the operating agreement, and I'll even add the operating agreement. Okay?
So we can interpret, if that's all we're talking about, we can interpret it just as well as the district court is. And which is maybe why Judge Gardner, in her illustrious opinion, said it's treated a lot like summary judgment, because that's what we do in summary judgment. We love district courts, especially the two of us, since we're former district court judges, but the reality is we can look independently at those written agreements.
That's correct.
And interpret.
That's correct.
Now, we may or may not agree with your argument, but we have that, not discretion, but that's our authority. Okay.
Agreed.
What's your argument to counsel's claim that you failed to ask for specific findings of fact?
Well, there were no specific findings that to be made, frankly, Your Honor, because the evidentiary record before the court were the three documents I just identified. And her conclusion, the district court's conclusions, okay, are, as the judge has said, essentially ones you can reach de novo, that's your scope, and there were no findings to I mean, the dates were the dates, right? And there's a created date in the amendment, there's an effective date in the management services agreement. The amendment was signed first, then the day later, But the amendment says these are contemporaneous agreements together. That's contemporaneous agreements, right? So whatever the minute-by-minute chronology might have been, one could not reasonably conclude that at the same time I'm doing the amendment and I'm saying nothing else has changed in the operating agreement, that we're making this fundamental change to the operating agreement, which is we're deleting the arbitration provision. That's not a reasonable conclusion to reach from the record before the court and before the evidentiary record in the district court. On the receivership order, Your Honor, again, it's not an interference with the exclusive jurisdiction. Okay? It's a different forum to which, under contract, okay, a party was entitled to. And there's no dispute really, there was an enforceable arbitration provision. Okay? That's not really a question. The issue is, what impact, if any, did or could the receivership order have on what is plainly an arbitration provision that covers this dispute in this case? Okay?
But once in a receivership, once the court, basically the court in a way is the ultimate receiver, because everything now is under the control of the court. At the very least, it seems the court at that point, for lack of a better term, owned the cause of action, owned the claim made by the receiver. And so certainly, you could argue, and you have, that the court abused its discretion, but it seems like it has, if it's the one that now has the kind of for lack of, again, better term, in rem jurisdiction over that property, including the claim, that it has to make that first call about whether or not it's going to grant leave under the terms of the receivership for you to pursue your claim to right to arbitration.
Well, but if there is an arbitration agreement that's enforceable, and given the...
Well, and who can enforce it is really a big issue here.
Well, the parties agreed in that sense, yes. Who can enforce?
Because I don't think anybody doubts that original operating agreement had an arbitration clause.
And I'm saying, and the
Yeah.
parties get the benefit of that, or the obligations of that. And counsel's argument on third parties essentially was, well, assume that Element's not a party, and assume that the managers aren't parties. So, in my judgment, don't follow the statute. Assume that, well, yeah, then they are third parties. But they're parties to the agreement by virtue of the statute.
I've given you about 20 minutes total to argue, so why don't you take about 30 seconds
Okay.
and wrap it up if you would, please.
On the receivership order again, Your Honor, think of this kind of situation. So, there's a claim the receiver has, Element has. Element brings the claim against whoever, vendor, whoever, and it's removable. Okay? Can they remove it? Does this receivership order preempt the federal removal statute that gives everybody a right to remove their case to federal court? I think not. And I think this is much like that. So again, I think there's a legal error committed, but I don't believe that the receivership order, by its plain literal language, overruled, to borrow the language from the district court, overruled the arbitration agreement.
Well,
Thank
thank
you,
you
Your Honors.
both. Good
Thank
arguments by both counsel. We'll take this under advisement and try to get an opinion out as quickly as possible so you can go wherever you're going to go. Something tells me this isn't going to end here, but if you want to talk settlement in the hallway, feel free.